Question 1. An agent wishes to share in the profits and losses of a customer's account. Under the Uniform Securities Act, USA, which of the following statements is true? A. Sharing is permitted only if the agent contributes capital proportionate to their share of profits and losses. B. Sharing is prohibited under all circumstances. C. Sharing is permitted if the customer and the agent's broker-dealer provide written consent. D. Sharing is permitted only if the agent acts in a fiduciary capacity and the customer agrees. Answer: C. Sharing is permitted if the customer and the agent's broker-dealer provide written consent. Under the Uniform Securities Act, an agent is generally permitted to share in the profits and losses of a customer's account, provided they obtain written authorization from both the customer and their employing broker-dealer before engaging in such an arrangement. This rule allows for flexibility while ensuring transparency and proper oversight. However, even with consent, it is important to remember that such arrangements typically require the agent to share proportionately in the account's capital contributions. Always ensure you have all necessary approvals before sharing in a client's account. Question 2. Under the Uniform Securities Act, USA, a person who represents an issuer in effecting transactions in that issuer's own securities would be considered an agent unless the transactions are: A. In federal covered securities. B. In exempt securities or exempt transactions. C. Executed through an investment advisor. D. Solicited by the issuer's principal. Answer: B. In exempt securities or exempt transactions. The Uniform Securities Act defines an agent as an individual who represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. However, a specific exclusion exists for individuals representing an issuer in transactions involving exempt securities, like U.S. government bonds or municipal bonds, or those involving exempt transactions, such as private placements or unsolicited trades. This exemption recognizes that certain less risky or highly regulated activities do not require the same level of agent registration. Remember that if the securities or transactions are not exempt, the individual representing the issuer would likely need to register as an agent. Question 3. Under the Uniform Securities Act, USA, which of the following statements regarding the registration of an investment advisor, IA, is false? A. An IA's registration automatically registers any investment advisor representatives, IARs, employed by the IA. B. An IA that primarily advises federal covered securities generally registers with the SEC, not the state. C. The administrator may require an IA to post a surety bond. D. An IA must consent to service of process when applying for registration. Answer: A. An IA's registration automatically registers any investment advisor representatives, IARs, employed by the IA. The registration of an investment advisor, IA, does not automatically register its investment advisor representatives, IARs. Under the Uniform Securities Act, IARs are individuals who provide investment advice on behalf of the IA, and they must register separately with the states in which they have a place of business or where they advise more than a de minimis number of non-institutional clients. While the IA is responsible for ensuring its IARs are properly registered, each IAR must fulfill their own registration requirements. Think of it like a firm registering as a company. Its individual employees still need their own licenses. Question 4. An investment advisor representative, IAR, is moving from State A to State B. Under the Uniform Securities Act, USA, what notification is generally required? A. Only the IAR must notify the administrator of State B. B. Only the employing investment advisor must notify the administrator of State A and State B. C. The IAR and the employing investment advisor must both promptly notify the administrator of State A and State B. D. No notification is required until the IAR begins soliciting clients in State B. Answer: C. The IAR and the employing investment advisor must both promptly notify the administrator of State A and State B. When an investment advisor representative, IAR, terminates employment with an investment advisor, IA, or changes states, both the IAR and the employing IA have a responsibility to promptly notify the administrator. This dual notification ensures that state regulators are aware of changes in registration status and location, allowing them to maintain accurate records and oversee individuals providing investment advice within their jurisdiction. It's a key component of maintaining regulatory oversight and protecting the public. This ensures all parties are aware of the IAR's updated registration status. Question 5. Under the Uniform Securities Act, USA, which of the following statements regarding a cease and desist order issued by the administrator is true? A. It can only be issued after a formal hearing has been conducted. B. It requires court approval before it can be enforced. C. It is a temporary directive issued to prevent further violations, pending a hearing. D. It can only be issued against individuals, not firms. Answer: C. It is a temporary directive issued to prevent further violations, pending a hearing. A cease and desist order is a powerful tool used by the state administrator to immediately stop a person or entity from engaging in activities that violate the Uniform Securities Act or are likely to cause harm to the public. This order is a temporary measure, issued without a prior hearing, to prevent further illegal conduct while an investigation or formal proceeding is underway. The recipient typically has the right to request a hearing to challenge the order, but it remains in effect until that hearing determines otherwise. Think of it as a regulatory stop order to protect investors quickly. Question 6. A security sold in an isolated non-issuer transaction would be considered: A. An exempt security under the Uniform Securities Act, USA. B. An exempt transaction under the Uniform Securities Act, USA. C. A federal covered security. D. Subject to full registration requirements under the Uniform Securities Act, USA. Answer: B. An exempt transaction under the Uniform Securities Act, USA. An isolated non-issuer transaction refers to a transaction between individuals that is not part of a broader offering by the issuer, such as a casual sale between two individuals. Under the Uniform Securities Act, such transactions are typically considered exempt transactions, meaning they do not require registration with the state administrator. This exemption is designed to avoid burdening individuals with extensive registration requirements for infrequent, non-public sales. Always remember that an isolated non-issuer transaction refers to the transaction itself being exempt, not the security. Question 7. Under the Uniform Securities Act, USA, what is the maximum criminal penalty for a person found guilty of willfully violating the Act? A. $10,000 fine and/or 5 years imprisonment. B. $5,000 fine and/or 3 years imprisonment. C. $25,000 fine and/or 10 years imprisonment. D. $50,000 fine and/or 15 years imprisonment. Answer: A. $10,000 fine and/or 5 years imprisonment. The Uniform Securities Act outlines specific criminal penalties for individuals who willfully violate its provisions. A person found guilty of such a violation may face a maximum fine of $10,000, imprisonment for up to 5 years, or both. It's crucial to understand that these penalties apply to willful violations, meaning the person acted with knowledge that their conduct was illegal. This emphasizes the seriousness with which state regulators view breaches of securities law. Question 8. Under the Uniform Securities Act, USA, which of the following would not be considered a security? A. A common stock. B. An investment contract. C. A fixed annuity contract. D. A variable annuity contract. Answer: C. A fixed annuity contract. Under the Uniform Securities Act, a fixed annuity contract is generally not considered a security because the insurer bears the investment risk and guarantees a fixed rate of return. In contrast, common stock, investment contracts, meeting the Howey test, and variable annuity contracts are typically classified as securities. Variable annuities are securities because their value fluctuates based on the performance of an underlying investment portfolio, transferring investment risk to the contract holder. Remember that securities generally involve an investment of money in a common enterprise with an expectation of profits derived primarily from the efforts of others. Question 9. An investment advisor, IA, with discretionary authority over client accounts must generally obtain A. Oral authorization from the client for each trade. B. Written authorization from the client for each trade. C. Written discretionary authority from the client prior to executing trades. D. No specific authorization, as long as the IA acts in the client's best interest. Answer: C. Written discretionary authority from the client prior to executing trades. For an investment advisor to exercise discretionary authority, meaning they can make investment decisions, what security, how much, and when to trade, without specific client approval for each trade, they must first obtain written authorization from the client. This written consent ensures that the client explicitly understands and agrees to grant this significant power to the advisor. This requirement protects clients by providing a clear record of their consent for the IA to make investment decisions on their behalf. Always confirm you have proper written authorization before engaging in discretionary trading. Question 10. Under the Uniform Securities Act, USA, which of the following is typically exempt from state registration as a security? A. Common stock issued by a publicly traded microcap company. B. A security issued by the U.S. government or a municipal government within that state. C. An interest in a limited partnership. D. Corporate bonds issued by a foreign private issuer. Answer: B. A security issued by the U.S. government or a municipal government within that state. Securities issued or guaranteed by the United States government, any state, or any political subdivision of a state, like municipal bonds, are generally exempt from state registration requirements under the Uniform Securities Act. This exemption is based on the perceived safety and regulatory oversight of these governmental entities, making their securities less risky for investors. While these securities are exempt from state registration, broker-dealers and agents selling them must still be registered. Question 11. An agent of a broker-dealer sells an unregistered non-exempt security in a non-exempt transaction. Under the Uniform Securities Act, USA, this action is A. Permissible if the agent acted in good faith. B. Permissible if the transaction was small. C. A violation of the Act. D. Permissible if the client was sophisticated. Answer: C. A violation of the Act. Under the Uniform Securities Act, it is a violation to offer or sell an unregistered non-exempt security in a non-exempt transaction. All non-exempt securities must be registered with the state administrator or qualify for an exemption before they can be legally offered or sold within that state. The intent of this rule is to protect the public by ensuring that investors receive adequate disclosure about securities being offered. Ignorance or good faith is not a defense for violating securities registration requirements. Question 12. Under the Uniform Securities Act, USA, an administrator has the authority to A. Set minimum capital requirements for broker-dealers. B. Issue subpoenas and conduct investigations. C. Approve the financial soundness of a new security issue. D. Mandate specific investment returns for clients. Answer: B. Issue subpoenas and conduct investigations. The state administrator, the chief securities regulator in a state, is granted broad investigative powers under the Uniform Securities Act. These powers include the ability to issue subpoenas to compel testimony or the production of documents, administer oaths, and conduct public or private investigations into potential violations of the Act. These tools are essential for the administrator to enforce securities laws and protect investors within the state. Remember, the administrator's role is to regulate and enforce, not to guarantee investment performance. Question 13. Which of the following is considered an unethical business practice for an agent under the Uniform Securities Act, USA? A. Charging reasonable commissions for transactions. B. Exercising discretion in a customer's account based on oral instructions without written authorization. C. Recommending only highly rated investment-grade bonds to a risk-averse client. D. Providing educational seminars about general investment principles. Answer: B. Exercising discretion in a customer's account based on oral instructions without written authorization. Exercising discretion in a customer's account solely based on oral instructions, without obtaining prior written authorization, is considered an unethical business practice for an agent. Discretionary authority grants an agent significant power over a client's assets, and written consent is a fundamental safeguard to ensure the client explicitly agrees to this arrangement and that a clear record exists. This rule protects clients from unauthorized trading and helps prevent misunderstandings. Always secure written permission before making discretionary trades. Question 14. Under the Uniform Securities Act, USA, which of the following statements about the renewal of registrations is true? A. All registrations expire annually on December 31st unless renewed. B. Registrations typically renew automatically without any action required. C. Initial registration is valid for 2 years before requiring renewal. D. Renewals are only required if there is a material change in registration information. Answer: A. All registrations expire annually on December 31st unless renewed. Under the Uniform Securities Act, the registration of broker-dealers, agents, investment advisors, and investment advisor representatives typically expires annually on December 31st, requiring them to renew their registration to continue operating legally. This annual renewal process allows state administrators to review registration information, collect fees, and ensure that all registered parties remain qualified and compliant with state securities laws. It's a key administrative function for maintaining regulatory oversight. Question 15. The Uniform Securities Act, USA, defines an investment advisor as a person who A. Is a broker-dealer engaged in the business of effecting securities transactions for others. B. Issues or proposes to issue any security. C. For compensation, engages in the business of advising others as to the value of securities or the advisability of investing in, purchasing, or selling securities. D. Represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. Answer: C. For compensation, engages in the business of advising others as to the value of securities or the advisability of investing in, purchasing, or selling securities. The Uniform Securities Act defines an investment advisor, IA, using a three-pronged test: providing advice about securities, doing so as part of a regular business, and receiving compensation for that advice. This definition is crucial for determining who must register as an IA with state securities administrators or the SEC. This comprehensive definition captures individuals and firms whose primary activity involves offering paid securities advice. Question 16. Under the Uniform Securities Act, USA, which of the following actions requires a broker-dealer to maintain a surety bond? A. Transacting business with institutional clients only. B. Having custody or discretion over client funds or securities. C. Operating solely within a single state. D. Dealing exclusively in exempt securities. Answer: B. Having custody or discretion over client funds or securities. Under the Uniform Securities Act, a state administrator may require a broker-dealer, or investment advisor, to post a surety bond if they maintain custody of client funds or securities, or if they have discretionary authority over client accounts. The purpose of a surety bond is to provide financial protection for clients against potential losses due to fraud, mismanagement, or other misconduct by the firm. This requirement helps safeguard client assets and ensures accountability. Question 17. An investment advisor representative, IAR, must register in a state if they have a place of business in that state or if they A. Exclusively advise federal covered securities. B. Advise more than 5 retail clients in that state within a 12-month period, even without a place of business. C. Only advise institutional clients in that state. D. Merely publish a financial newsletter from another state. Answer: B. Advise more than 5 retail clients in that state within a 12-month period, even without a place of business. The de minimis exemption under the Uniform Securities Act states that an investment advisor representative, IAR, does not need to register in a state where they do not have a place of business, provided they do not direct business communications to more than 5 non-institutional clients, retail clients, who reside in that state within any 12-month period. If an IAR exceeds this threshold of 5 retail clients, even without a physical office, they must register in that state. This rule ensures that individuals providing advice to a significant number of residents are subject to state oversight. Question 18. Under the Uniform Securities Act, USA, which of the following is considered a person? A. An individual. B. A corporation. C. A partnership. D. All of the above. Answer: D. All of the above. In the context of the Uniform Securities Act, the term person has a very broad definition. It includes not only natural individuals but also legal entities such as corporations, partnerships, trusts, unincorporated organizations, governments, and political subdivisions of governments. This expansive definition ensures that all entities involved in securities activities are subject to the provisions and regulatory oversight of the Act. Understanding this broad definition is fundamental to understanding who the USA applies to. Question 19. A broker-dealer must register with the state administrator if they: A. Have an office in the state. B. Solicit business in the state. C. Execute transactions with clients in the state. D. All of the above. Answer: D. All of the above. Under the Uniform Securities Act, a broker-dealer is generally required to register with the state administrator if they have an office in that state, solicit business within that state, or effect securities transactions with clients who are residents of that state. The Act aims to regulate all broker-dealer activities that impact the residence or physical presence within a state. Even if a broker-dealer has no office in a state but solicits or executes trades for residents, registration is typically required, underscoring the broad reach of state securities laws. Question 20. Under the Uniform Securities Act, USA, a consent to service of process typically: A. Gives the administrator the power to arrest individuals. B. Allows legal documents to be served on the administrator if the registrant cannot be found. C. Requires registrants to maintain all records within the administrator's office. D. Permits the administrator to review a registrant's tax returns. Answer: B. Allows legal documents to be served on the administrator if the registrant cannot be found. When applying for registration under the Uniform Securities Act, applicants, such as broker-dealers, agents, investment advisors, and IARs, must file a consent to service of process. This document is a legal agreement appointing the state administrator as the applicant's attorney for receiving legal papers. This means that if a registrant cannot be found, legal documents, such as subpoenas or complaints, can be served on the administrator, ensuring that legal proceedings can still move forward. It provides a crucial mechanism for legal recourse against out-of-state or hard-to-locate registrants. Question 21. Which of the following would constitute commingling of funds by an agent? A. Placing customer cash in a separate client escrow account. B. Combining customer securities with the agent's personal securities for safekeeping. C. Using client funds to pay for the broker-dealer's operational expenses. D. Receiving a commission from a transaction. Answer: B. Combining customer securities with the agent's personal securities for safekeeping. Commingling is the unethical and illegal practice of mixing client funds or securities with the firm's or agent's own assets. When an agent combines customer securities with their personal securities, it blurs the lines of ownership and can expose client assets to the agent's personal financial risks or creditors. Broker-dealers and agents must keep client assets strictly separate from their own accounts to protect client funds and prevent fraud. Always maintain strict separation between client and personal assets. Question 22. Under the Uniform Securities Act, USA, a security is considered federal covered if A. It is registered with the state administrator. B. It is traded only within a single state. C. It is registered under the Securities Act of 1933 or listed on a national exchange. D. It is issued by a non-profit organization. Answer: C. It is registered under the Securities Act of 1933 or listed on a national exchange. The National Securities Markets Improvement Act of 1996, NSMIA, introduced the concept of federal covered securities. These are securities that are exempt from state registration requirements because they are already registered with the SEC under the Securities Act of 1933, example IPOs, or they are listed on a national securities exchange like the NYSE or NASDAQ. NSMIA aimed to reduce regulatory duplication by preempting state registration for these securities. While states cannot require registration, they may still require notice filings and collect fees for federal covered securities sold within their borders. Question 23. An investment advisor, IA, may charge a performance-based fee to a client under the Uniform Securities Act, USA, if the client is A. A high net worth individual or institutional investor. B. Any client, provided there is full disclosure. C. Any client, as long as the fee is lower than a fixed fee. D. Only clients of a federal covered advisor. Answer: A. A high net worth individual or institutional investor. Under the Uniform Securities Act, and generally under federal law, performance-based fees are typically prohibited for investment advisors unless the client meets specific criteria as a qualified client. These qualified clients are generally individuals or institutions with a high net worth or significant assets under management, as they are presumed to be sophisticated enough to understand and bear the risks associated with such fee arrangements. This rule prevents less sophisticated investors from being exposed to the potentially speculative nature of performance-based compensation. Question 24. Under the Uniform Securities Act, USA, the statute of limitations for civil liabilities is typically A. 1 year from discovery of the violation, or 3 years from the date of the transaction, whichever is earlier. B. 2 years from discovery of the violation, or 5 years from the date of the transaction, whichever is earlier. C. 3 years from discovery of the violation, or 7 years from the date of the transaction, whichever is earlier. D. 5 years from discovery of the violation, with no outside limit. Answer: A. 1 year from discovery of the violation, or 3 years from the date of the transaction, whichever is earlier. The Uniform Securities Act sets a specific statute of limitations for investors to bring civil actions to recover damages for violations. An investor must typically initiate such an action within 1 year after discovering the violation, or within 3 years after the date of the transaction that constitutes the violation, whichever comes first. This limitation period is designed to provide a reasonable timeframe for claims while also ensuring finality for transactions. Missing these deadlines means losing the right to sue. Question 25. Under the Uniform Securities Act, USA, an administrator can deny, suspend, or revoke a registration for an applicant or registrant if A. They have insufficient experience in the securities industry. B. It is in the public interest and the applicant/registrant has committed a disqualifying act, example criminal conviction, materially misleading application. C. They fail to achieve a certain level of client satisfaction. D. They are involved in a civil lawsuit, regardless of the outcome. Answer: B. It is in the public interest and the applicant/registrant has committed a disqualifying act, example criminal conviction, materially misleading application. The administrator has the authority to deny, suspend, or revoke a registration, but this power is not absolute. The administrator must find that the action is in the public interest and that the applicant or registrant has committed a specific disqualifying act, such as providing materially misleading information on an application, being convicted of a securities-related misdemeanor or felony, or violating securities laws. This two-pronged test ensures that regulatory actions are both justified and necessary for investor protection. Simply having insufficient experience or being involved in a civil suit alone would typically not be enough cause for denial.